Bush and Richard Cheney.
Mr. Richard, let me start with my question that I asked Mr. Boyce. When this case was here before, counsel for Mr. Bush did not present any argument on McPherson versus Blacker, yet when it got to the Supreme Court, counsel for Mr. Bush forcefully argued McPherson versus Blacker. Now I know that it's not argued again here. Is it the position of Mr. Bush that that case does not have any bearing on this matter?
Oh, Your Honor, I think that the case has substantial bearing on the matter. I think that what McPherson v. Blacker tells us is exactly as Your Honor suggested it, which is that this court does not have the ability in this particular case involving presidential electors to disregard the statutory scheme and fashion a remedy based upon extraordinary equitable powers of the court set forth in the Constitution.
Do we have the right to review the action of the circuit court?
Indeed you do, Your Honor, but we come here in a significantly different posture than we did before. What we come here with now is belied by the nature of the litigants and the public interest. In fact, this is nothing more than a garden variety appeal from a final judgment by a lower court that reviewed after an entire full evidentiary hearing.
But the legislature, having plenary power, said that the circuit court will make that determination.
Well, I agree with you, Your Honor, and I would not suggest to this court that the circuit court is not subject to any appeal. I believe that the circuit court is subject to appeal, but in a very limited fashion. And I also think that one reason that we have not placed emphasis upon McPherson versus Blacker is because, in fact, this court said the same thing in an earlier McPherson case, which Justice Wells referred to, McPherson versus Flynn, in which this court said, since there is no common law right to contest elections, any statutory grant must necessarily be construed to grant only such rights as are explicitly set out by the